The 1984 model law grants wide powers to the tribunal to grant interim relief. Article 17 states, unless otherwise agreed by the parties, the tribunal may, at the request of a party, order any party to take such interim measures of protection as the tribunal may consider necessary in respect of the subject matter of the dispute. The tribunal may require any party to provide appropriate security in connection with such measure. It is a short provision, but it gives great latitude to tribunals. There is no limitation of the relief that a tribunal may grant. It is accepted that a tribunal may grant a very wide range of interim relief. The 1984 model law does not prescribe the test to be applied by the tribunal. It is open to the tribunal to determine the tests. One possibility is to apply the test for interim relief used by the courts in the seat of arbitration for litigation in that court.
It's quite hard, as I hope I've demonstrated, to really precisely define what mediation is and what mediation is not. It might be easier to start by thinking about the objectives of mediation. And there can be quite different purposes or objectives or goals for mediating, depending on the perspective you take. So from the court's perspective, service delivery is often major objective, and that means getting people access to a resolution swiftly and inexpensively. All right, so rather than waiting a long time for a day in court and that costing a lot of money, that you can have a cost-effective and quick, relatively painless solution outcome for your dispute.
The arbitration begins. So now you have a tribunal constituted. What kind of role can the court provide? So one is that occurs is, for instance, if you have a challenge against an arbitrator. That type of challenge against an arbitrator, depending on the type of arbitration you have, you ultimately can seek a determination from the courts as to whether that arbitrator is qualified or disqualified, particularly if they have like a conflict. Another very important area where the courts can support the arbitration is the taking of evidence. As you know, a tribunal does not have compulsive powers. So, for instance, they might be seeking certain types of evidence, or the parties might be seeking certain types of evidence, particularly like a certain witness.